brought to you by Synergy Settlement Services. The third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon, and thank you for attending our third Thursday webinar. This presentation will be on hospital liens, cost transparency, and whether this new move towards cost transparency is a good or a bad thing. My name is Michael, the last name is Wallrath, and I am a practitioner, a litigator who has dealt only with this one particular issue my entire career. From inception, I've only litigated the reasonable value of healthcare, and I've done it in a bunch of different contexts. The last, I'd say, 10 years or so in the context of hospital liens against personal injury settlements, and I've since joined Synergy and now bring you this information as part of their new hospital services. So first, I wanted to start with a topic that I think you all have probably seen in the news lately, and that is price transparency. There was quite a flurry of activity recently in the media about some regulations through PPACA, also known as Obamacare, which came to fruition just this January, and that they deal with price transparency. Now, price transparency is basically the linchpin of the principle that if people understand the prices of the goods and services that they're purchasing, then market forces can work, and those consumers will be able to make better decisions, and ultimately those decisions through competition will bring prices down. It's been believed for a long time that the fact you don't know the prices of hospital care contributes to this sort of wild, wild west of hospitals charging whatever they want. Obamacare did require those hospital prices to be published in an online format and downloadable, and those requirements kicked in on January 1st of this year. So that's why you've seen all of the recent news articles. Basically, CMS described it as creating a patient-centered healthcare system by achieving greater price transparency. So the entire point is to make consumers aware of the prices of healthcare. And the pros, of course, are that if consumers can understand the prices and meaningfully compare them, then they would be able to make better informed decisions. The cons, of course, are that they can't. They can't possibly use charge master price lists to determine the cost of their health care. It simply doesn't work. And the other big con that we're going to get into is that judges and legislators might very well believe that it would work. So we start with the concept of the open price term contract, and that's important to understand because it is the underpinning of most arguments to reduce hospital liens and hospital accounts in general. It's a creature of both statutory lien law as well as the common law in most states. Basically, it goes like this. A patient agrees to pay for hospital care in an admission contract that usually says something like, I agree to pay for all the charges that I incur, and then the hospital and the patient essentially have left open the price term. They've left it undefined. The hospital then treats the patient, issues their oftentimes unreasonable hospital bill, and the patient can challenge that bill as unreasonable because there was never an agreement to price. So the question is, does this new transparency, does this new posting of hospital charge master price lists supply the missing price term? And my only answer is, let's hope not. Charge master prices are paid by significantly less. I hear the number 3% tossed around often, 3% of the patient population. So nobody pays these charges. Charge master prices are many times the cost of care on some services, oftentimes more than 20 times the cost of care. For example, CT scans. You'll see CT scans, and we'll go through some specific examples later, where prices are inflated 20 times above cost. Charge master prices do not include the prices for procedures. So in short, you cannot use the charge master price list to compare what your bill will be across providers. But be prepared to argue and educate whomever it is that you have to explain this to. Judges don't understand it. And the hospital reps that you often will be negotiating against in reducing your hospital liens, I would venture to say they do understand it, but will sort of pretend that they don't, and will use this argument that these prices are now available to try to either insinuate or flatly say that your client agreed to them. It's just super important to reiterate that patients don't know what services they'll get when they enter the hospital. If they do know what services they'll get, they're described in terms of procedures. You're having XYZ procedure, and you would conceivably be able to look up the price of that procedure, except for one thing. Charge master price lists do not include the prices for procedures. Charge master price lists only include charges that appear on a hospital bill. It includes basically a master list of all the charges that you see on a big, long, coded, itemized hospital bill. And they are defined in terms of the amount of time that the patient spent in the operating room, for example, or the amount of time under anesthesia or time in the recovery room during the procedure. So the reality is, using the charge master price list itself simply cannot be added up to determine what a bill will be for any given hospitalization. In fact, I oftentimes in my litigation will ask in discovery to, and it works best in depositions, to have someone at the hospital explain what use the charge master price list to explain what the charges for this particular procedure would have been. And I ask, could that have been done prior to the procedure being rendered? And the answer is, even an expert from the hospital, even folks I've deposed that are the person with most knowledge of the charge master price list, cannot sit down with a copy of that price list and tell you how much it would cost to have an appendectomy or to fix a broken arm. It just simply can't be done from a charge master. So it's very important to educate judges if you're litigating this, or be aware of the argument against hospital representatives trying to pretend otherwise. If a hospital can successfully argue that these prices are now publicly available, then liens in the amount of full bill charges could in fact become per se reasonable by contract, because they would essentially eliminate the argument that you had an open price term contract under which only reasonable prices are due. Some states have already went that direction, frankly. Maryland and Arizona both effectively have held at the highest levels that their hospital charges of all the hospitals in their states are per se reasonable, because their charge masters have been submitted to the government and basically approved. So as many of you know, most states do have hospital lien laws. This is a list intended to be complete, probably missing a few. Some states have more than one, Florida coming to mind, which has, I believe there's 20 some counties that have lien ordinances of one form or another. It's all by county in Florida. Other states like California have more than one. Virginia has more than one, differentiated between the type of hospital, whether it's private or public. So it's important to look at your own state's lien statute, as that will of course govern your legal responsibilities at least. As I mentioned, here's a few of the liens in some of the states that limit them to reasonable charges. I will say most lien laws are limited to reasonable charges. So this is not a complete sampling. I would say that the vast majority of states that have lien ordinances do limit them to reasonable hospital charges. In addition, the common law in most states requires reasonable charges under an open price term contract, as we discussed. So in California, a hospital has the burden to prove by a preponderance of the evidence that the amount of the lien is reasonable. In Florida, a patient may not be bound by unreasonable charges in an agreement to pay charges in accordance with standard and current rates. This is the exact open price term argument that I was referring to. If a contract does not include a price, the hospital is limited to reasonable compensation. That case in Florida led to quite a few other cases that say the same thing. Illinois, another example of good common law that says that the lien implies that there is an agreement to pay a reasonable price for the goods and services. And Georgia, you have some good language in the Bowden case that says what similar buyers and sellers have paid and received for the same product in the same market is relevant to the reasonable value of the healthcare. Lastly, Louisiana, a reasonable sum for services rendered usually includes the actual cost, including general overhead attributable to the project, and a reasonable profit. So that is something that I want you to remember. Cost plus a reasonable profit is probably the simplest definition of a reasonable hospital charge. But again, check your home state's case law for reasonableness requirements. They do differ from state to state. Interestingly, and probably not surprisingly to most of you, most hospital charges are unreasonable. They're unilaterally set. These are the charge master rates that are going to now be publicly available to everyone. There's usually no regulatory oversight, and there's no regard for the costs incurred by the hospital in rendering the care. I say that not just to be a contrarian, but having deposed several people who create the charge master price lists and adjust them annually, everyone has told me that they can point to no correlation between the cost of care and the charges that they put on their bill. It's just simply a made-up number that they manipulate to manipulate their profits based on the various managed care contracts that they go through for their varied patient population. So if you look at a charge master price list on average, hospitals do report a lot of data, so some of these averages are available. Usually you see somewhere between 4 and 10 times a hospital's cost of care is their charges. So basically the cost of care is a real number. These charge master rates are a vastly inflated and wishful number. Some of the individual charges, as I mentioned before, like CT scans, are unbelievably inflated, and we will go through some of those in a moment. I believe that slide was already given. So here's the CT scans, and take a look at these costs in the right-hand column. So this was all on one bill, $22,000, almost $23,000 worth of CT scans. The cost of care to the hospital, according to their own self-reported and sworn cost data that they submitted to the federal government under oath as part of their Medicare compliance, it's only $500. They're looking for more than a $22,000 profit on these 4 CT scans. If that is not unreasonable, I really don't know what is. There was a recent study that was published in Health Affairs, which is one of the nation's sort of gold standard health journals, and it identified the 50 worst hospitals with the highest markups above cost in the country. It found that on average, the hospitals were charging 3.4 times their cost, and that's on average nationally. In some states like Florida, those averages are much, much higher. And interestingly, that average has tripled from 1.35 times their costs, which if you think about it, that's a 35% profit margin. That's pretty reasonable, very reasonable actually. I would say I offer most hospitals considerably more than 35% profit to resolve these liens. But now it's up to 3.4 times the average cost of care. The study had an average of 10 times their cost in the top 50 hospitals. So the hospitals that were the worst, the 50 worst hospitals, on average were charging 10 times their cost, more than 1,000% markup above cost. Here's a short list of some of them. Actually, I think I have all 50 here. I'm not gonna going to leave it up too long to go through them in general, but you will see a few patterns. Florida repeatedly appears. Florida seems to have quite a few of these hospitals in it. The hospitals were typically rural. The hospitals were typically private versus public. And this list is available, as this entire slide presentation will be, if you would like us to send it to you. So back to the cost of care plus a reasonable profit. Again, remember, that is probably the simplest definition of a reasonable hospital charge. And it's the one that I like to focus on when I'm litigating, because I believe that the jury is going to understand that far better than a complicated managed care argument of what their average reimbursement is, or any of the other factors that are arguably relevant, just a little tougher to digest. So if that definition is accepted, well, then it goes to reason that you can't even determine what a reasonable charge is without knowing the cost of care. And as that study pointed out, because that's the data they used, that data is available. And all these hospitals, they submit their cost of care data every year to the federal government. They do so in a report called the Hospital and Hospital Healthcare Complex Cost Report. It's form CMS 255296. And when they submit that report, their cost data is then out there and available to the world. Since they all submit their costs, and since most hospital liens are limited to reasonable value, it goes without saying you should access that data in order to negotiate your hospital liens. I do a lot of presenting to plaintiffs' firms across the country, and I like to always start by trying to figure out what you do first. How are you currently negotiating your hospital liens? And what I learn almost without exception is they're basically blind negotiations. You're basically discussing this lien with the hospital in terms of the full bill charges and requesting a discount off of those full bill charges, as if the full bill charge is the amount that you owe, as if the full bill charge is a reasonable hospital charge, which is the definition, the limitation found in most of the lien ordinances. And the fact of the matter is that just isn't true. You don't owe the full bill charge, so negotiating down from the full bill charge often results in paying far more than you should. Most of the firms that I speak with are essentially willing to resolve the lien at the best discount they can get. Very commonly, I will hear 20% or 30% off. I usually hear that a 40% discount off of full bill charges is basically a home run, that's considered a good discount, and they would almost always recommend their client accept that sort of a discount so long as the settlement can bear it. And keep in mind, most of this conversation of how much off, it obviously is case specific, and there are different ordinances or different statutes in all the states, which make it a little, tricky to talk about globally, but oftentimes equitable distribution is essentially built into those statutes. So I would here be talking about fully funded hospital liens. How much of a discount should you get off of a hospital lien when you do have the full amount of that bill being held in trust? What Synergy has done to assist in this area, because it does seem just so critically important to have this cost data, we've made that data available, and we do so through what we call reasonableness reports. And the reports basically calculate the cost of care from the hospital's own self-reported cost data from the report that I just showed you, the CMS report. And it takes that coded hospital bill, it pulls all of the non-billable charges, the charges that I believe you can argue shouldn't be on there at all because they're included in other charges or what have you. And it takes those charges that are appropriate and it reprices them, allowing you to dictate the reasonable value and support it with the hospital's own data so that you can negotiate up from the reasonable value and stop negotiating down from the illusory full bill charge and asking for a discount as if you ever owed that amount to begin with. I call that inverting the argument, and I found it to be very, very effective. So I wanted to go through an actual case study. This was a real bill, $95,457.12. Now, if you had negotiated this off of the full bill charge, just asked for a discount, and you were able to get a 20% discount, you would still be paying the hospital 641% profit on this bill. Even if you got a 30% discount, you'd still be paying almost 420% profit. And at that magical 40% discount that almost unequivocally firms that I speak to across the country say is a good discount, you're still paying 344% profit above the hospital's cost on this particular $95,000 bill. So if you look at the same case study, but you invert the argument, you argue up from reasonable value instead of down from a made-up number, which is effectively what their full bill charge is. So the report on this bill came back at $20,000 as the reasonable value. Now, I want to point out that just for background, these reports, this reasonable value that's estimated in the report, that's not the cost of care. We do add in a 50% profit above cost. So this 20,000 would be the cost of care plus 50% on this particular bill. So if you negotiated up from that number and add 25%, you're asking the hospital basically, well, how much more above the reasonable value do you have to try to exact from my patient? If you can get them to accept 25% above the reasonable value, or $25,000, you've secured a 74% discount. If you even have to go further and give them 50% above the reasonable value, go to 30 grand, you've gotten almost a 70% discount. And at 100% above the reasonable value, basically offering them twice what I would argue the law limits them to, you're still getting almost a 60% discount, which most folks that I speak with that are using the traditional model don't very often achieve even that 60% discount mark. So to give you a little more information about these reports in the event that anyone wants to consider them, I will use the same case study to try to show you how the pricing works. On that bill, again, $95,457.12, if the hospital in that instance accepted the 30% discount, which it did on this case, the report that was before the plaintiff attorney ordered the report, they basically had already on the books a $66,000 offer. The report came back and the attorney used it to negotiate and accepted 50% above the reasonable value in this case. The synergy fee, therefore, was 10% of that additional savings. So the fee was $36.82, which ended up being a net savings to the client of $33,137.98. So that means, as with all of Synergy's lien resolution services, these reports are always a savings to the client. They are never a cost to the client. And if we do not obtain, or you do not obtain using one of these reports, an additional discount, the reports are free. So I typically ask firms after we've went through what they're normally doing, when's the last time you negotiated one of your personal injury settlements using no information or data other than the numbers provided by the defense? And as you can imagine, and I think you would probably all agree, the answer is never, because you would never just rely on their numbers. Having your own information, your own data, and negotiating from your end always works better. And that's why I think it's so important that you use that same philosophy here. And you don't start from the hospital's unreasonable full bill charge in these negotiations. You instead use the data and analysis that's available and available at no risk. Remember, when these reports are unsuccessful, which is very infrequent, there's no cost whatsoever. So having these reports is a risk-free way to ensure you know what you are negotiating for. So in conclusion, I wanted to end where I began and remind you about this argument that I expect you'll be seeing more and more from hospitals when you negotiate your hospital liens. I think you'll be seeing, now that these prices, these charge master price lists are being posted and are available online and there's all this hoopla about it, you'll start to see the hospital lien negotiators trying to claim that your client had access to these prices. The contract that they signed said they would pay the prices, so it's not an open price term contract. It is now a regular contract, one which the court cannot protect your client from their own bad bargain. I just really can't urge you enough to push back on that argument. These are still open price term contracts because the client did not know what services they were going to receive. And even if they did know what services they were going to receive, they wouldn't be able to use that charge master price list to calculate their bill because the price list itself is not, it's not organized into procedures. So unless they knew exactly how many minutes they would spend in each department and every supply they would use in a surgery, which they don't, then they cannot use that price list. And so the argument really is just not fair, not good, and shouldn't prevail. Though I could imagine state legislatures with the correct, or from our point of view, incorrect pressures to go the way of Maryland and Arizona and begin passing laws that essentially bless these charge master price lists because they're available to the public. That would not be a good thing, but I could imagine it happening. Also, I wanted to remind you of the reasonableness reports. I think they are such a valuable tool, and it isn't every day in our practices that we have valuable tools that are essentially free unless they result in, positive impact for our clients. I always compare them to life care plans. Everybody will get a life care plan. Wouldn't it be nice if life care planners told you that their life care plans were guaranteed, and if they didn't result in additional recoveries, additional damages, then they would be free. They don't do that, but Synergy does. These reports are never going to cost your client a penny unless they are effective. And in those instances where they're effective, the reports are only 10 cents of every dollar that goes into your client's pocket from that hospital bill. So remember also that the fees for these reports can be passed along as agreed costs. So in addition to it always being a net positive for your client, they always make money by having you order one of these reports. They never spend money. The reports also, of course, don't cost the attorneys anything. They are passed along as costs. And I wanted to just give you an open invitation that if any of you face lien issues with hospitals or direct providers, letter of protection lien type scenarios, and you have any questions, please feel free to contact me anytime. I'm always available by phone or email. I'm happy to talk to you about these questions, whether or not it's a case you think that you're interested in having Synergy get officially involved in. So here's my contact number. Again, my name is Michael and the last name is Wallrath, and I really appreciate you all attending this third Thursday webinar, and I hope to hear from some of you soon and help you out with these lien issues. Thank you.